Imagine this, you spend your hard earned money on new smartphone, your washing machine, or even your dream car. Within weeks, the phone dies, the machine floods your home, or the seller vanishes into clouds. You can call the customer care repeatedly and nothing happens. Emails get ignored or met with some robotic reply that you don't like. You may feel frustrated, angry, and completely helpless. I see this story in practice every single week. But the truth is, you are not powerless. Indian law gives you power. Hello, I am Advocate Naman Dadhich. In this video, we will walk through the Consumer Protection Act of 2019. Not just the law, but a practical guide with sections and important Supreme Court judgments that are actually in courts and the exact step to take. Earlier, the principle was to caveat emptor, let the buyer be aware. Earlier risk was on the consumer, but as per the new Act of 2019, it has flipped to caveat venditor. That means let the seller be aware. This act has replaced the old 1986 Act to deal with modern realities like online shopping and complex services. At its heart, Section 2 Clause 9 gives you six powers, that is, the right to safety, the right to be informed, the right to choose, the right to be heard, and right to seek redressal, and at last the right to consumer awareness. These six rights are the bedrock of the consumer protection jurisprudence in India. In law, the one of the first questions that is being asked is, are you even a consumer in the eyes of law? The answer is very simple. If you become a consumer the moment you pay for the goods and services, even purchases online or some marketplaces like Amazon and Flipkart, or new recent one that are Blinkit and Zepto. The Act borrows the idea of consideration from the Indian Contract Act 1872. However, if you bought something purely for resale, you are excluded from the definition of consumer. But if you are purchasing for your personal use or to earn a livelihood from the machine, from a sole workshop or the business, you are fully protected in the eyes of law. The Supreme Court has made it clear in Laxmi Engineering Works versus PSG Industrial Institute 1995. Now the question is, what can be the grounds to the complaint? It has been seen multiple times that people can file complaints for defective goods, deficiency in service, unfair trade practices, or unfair contracts. Service under Section 2, Clause 42 is to be interpreted very broadly. This covers almost everything in the eyes of law. 2019 Act has also added a strong product liability chapter, that is from Section 82 to 87. Now you can hold the manufacturer directly responsible, something that is extremely useful when the sellers try to shift the blame to you. Recent innovation is also important to be taken care of, that is Central Consumer Protection Authority. CCPA is a watchdog that works for all consumers, not just individuals. It can investigate misleading ads, order product recalls, or even take action against celebrity endorsers who can make false claims. These things are to be understood related to the jurisdiction. That forum can adjudicate the case. It was updated in 2021, but as of now, these are the jurisdiction in consumer protection cases. Up to 50 lakhs, you have to go to a district commission. 50 lakhs to 2 crore, you can go to state commission. You have to go to state commission. And above 2 crore, it will directly lie to the national commission, that is in Delhi. It has to be noted that you file based on amount that you have paid, not on the compensation that you are claiming. The best part is now Section 34. That gives you a right that you can file the cases where you live or work. Earlier, the case was to be filed where the cause of action arose. But in this consumer protection, you have 2 years under Section 29 from the date of problem arose. But to be honest, it is always better to be act early. Though it is true that court do sometimes condone genuine delays. Now we'll understand the step-by-step procedure how to file a consumer complaint in India. In every case, this is the procedure that has to be followed. First, you have to send a strong legal notice. Many matters, in my opinion, get resolved at this stage only. It is seen that companies suddenly become responsive when you genuinely act on your rights. Second, if no response is received, draft a proper complaint with all facts, dates, and relief sought, supported by an affidavit that is being signed by you. All the pieces of evidence has to be attached: bills, email, photos, everything. Then you have to file it online on E-Jagriti portal. Fees are very low, often 0 up to 5 lakh rupees. The commission issues notices, hear both the sides, and then passes an order. At any stage, mediation is encouraged by the forum. Now the question is what relief you can get from the consumer protection authorities. The relief under section 39 are very wide and ample. That is refund, replacement, compensation for mental agony, punitive damages. These orders are as strong as civil court decrees. So these orders has to be executed in letter and spirit. At last, what can be said? The Consumer Protection Act 2019, strengthened by CCPA, product liability regime, mediation mechanism, and progressive Supreme Court judgment, provides one of the most robust and accessible consumer protection frameworks. It empowers every citizen with meaningful rights and effective remedies. Document your grievance properly, act within the limitation period, and assert your right regularly. If you are facing any consumer dispute, you can consult any qualified advocate. Thank you for watching. We'll see you in the next one.